Good evening, class. My name is Earldisha Crosdale, and I decided to do my project on the liability and wrongful custodial deaths. A brief overview. Every year, a small number of arrestees are dying in police custody. Sudden deaths in police custody after use of force confrontation are emerging as a critical area in police civil litigation. Although many arrestees are under some type of influence and become combative, it is common for the state to file a wrongful death claim against the administrators, the county, the officers involved. Let's find out why. As I mentioned before, a number of the arrestees become combative. This could be due to a mental illness or the fact that they're under the influence of some type of alcohol or some type of drug. Being combative then makes the officer have to use a form of physical force. In many cases, they hogtie the arrestee. Hogtying the arrestee is when the hands and legs are restrained, they're connected together, the legs are bent back towards the hips, and they're placed on their stomach. In many of these cases, the arrestee becomes unresponsive, and even after the emergency procedures are utilized, within minutes or hours of even being arrested, that individual is dead. It's an ongoing chain reaction because now the estate alleges that the agency as a whole was intentionally negligent, grossly negligent, or deliberately indifferent to the needs of that person. Intentional negligence being legal wrongs committed on purpose, gross negligence being conscious and voluntary disregard of the need to use reasonable care, and deliberate indifference being the conscious and reckless disregard of the consequences of one's acts. This leads us to the negligence components and the special duty of care while under law enforcement custody. Definitions of negligence, they vary state to state and usually include some type of behavior that leads to injury or damage. Officers have legal duties to deal with situations accordingly. However, to what extent is it negligence? To prove a negligence claim, legal duty, breach of duty, proximate causation, and actual injury all must be established. Special duty of care. Test 1. The officer's knowledge of the arrestee's mental state and the extent to which the condition renders the arrestee unable to exercise ordinary care. With that being said, if one does have a mental illness or is showing signs of being under the influence of intoxication or a drug, it may be owed if the officer has reason to believe the arrestee presents a great danger to themselves. Here are a couple of the landmark cases of negligence and the special duty of care. In Fruge versus City of New Orleans, a diabetic arrestee gave off some type of appearance as being intoxicated. The officers completely ignored all signs, threw him into isolation, and hours later, the arrestee died. In Del Tufo versus the Township of Old Bridge, an arrestee died from an overdose on cocaine while in police custody. It was after a traffic accident. The arrestee denied any medical assistance. In the backseat of the car, the arrestee began kicking the windows, and during the transportation to the police department, the officers observed the arrestee shaking violently and still did nothing. Within an hour of being at the hospital, the arrestee died of cardiac failure due to ingesting 3.5 grams of cocaine. In Brown versus Lee, an arrestee died from an overdose on ecstasy. He also denied medical attention, and even after the officers witnessed that he was acting hyper and out of the norm, they ignored all signs and went ahead and threw him in a cell, and hours later, he too died. This brings us to the wrongful custodial death claims under Statute 1983. Statute 1983 actually authorizes the application of any state remedial law that is consistent with the purposes to any situation for which federal civil rights laws do not provide an appropriate remedy. Under Statute 1983, wrongful death is filed when death results from excessive force, failure to attend to medical needs, and conduct of defendants and proximate cause of death under intentional tort principles, which also falls under gross negligence. Under Statute 1983, unexpected custodial deaths are evaluated within the purview of the 4th and the 14th Amendments based on deliberate indifference, objective reasonableness, and conduct shocking to the conscience. In other words, if it really just happened out of the blue, no one expected it, and there was really honestly no case of negligence, that's a conduct shocking to the conscience. Here are a few of the excessive force claims. In the estate of Phillips versus City of Milwaukee, officers used force to calm down a larger schizophrenic man with ballpoint pens in both hands. After a long fought struggle, the arrestee was handcuffed and placed in leg restraints and flipped on his stomach. Within a minute, he stopped breathing. First responders were unable to revive him, and a medical examiner determined that the restraint was contributed to his death. In East versus City of Chicago, East actually died of a drug overdose. In the middle of a drug raid earlier that day, East swallowed a plastic bag of cocaine. 4 hours later, in interrogation, he started hallucinating and attempted to hide under the table. A number of officers grabbed him from the table, kicked him in the head and between the legs, even hit him with a nightstick just to attempt to handcuff him. When East began to tell the police, hey, I swallowed cocaine earlier, they all told him, you're just afraid to go to jail. So they placed him in a cell where another prisoner later grabbed the attention of law enforcement and told him that East needed medical attention. It was undetermined how long it took for them to call the paramedics, but once the paramedics got there and got him to the hospital, East died. Here are a couple landmark cases of the use of restraint claims. For example, Cruz versus City of Laramie, Wyoming. Officers found Cruz running around naked, and he fought with officers who tried to detain him. After finally getting him, calm and in handcuffs, Cruz started kicking. Therefore, the officers were forced to hogtie him. After noticing Cruz became calm, his face blanched, and that's when the officers removed the restraints. Medical attention was sought, but Cruz was already dead. In this specific case, the 10th Circuit found that hog-tying people with diminished capacity was excessive force and denied the summary judgment for the City of Laramie. In each of these cases, Cruz, Price, Hill, and Lewis were all hog-tied and died within the range of police custody. Although my references were published in 2013, one case we must never forget is Miss Sandra Bland. Say her name.